Welcome to the Hastings Shadmary Show.
I'm Andy Hastings.
And I'm Mallie Shadmary.
Together, we own Hastings Shadmary, an Atlanta-based law firm specializing in family law.
This is a space where we talk all things family law and all topics that touch the area of family law, from divorce to custody to self-growth, personal empowerment, and more. We bring you the truth, from our wolf pack to yours. Hello, and welcome to the Hastings Shadmary Show. I'm Mallie Shadmary, and I'm by myself today. You're welcome. You get just me and you, a little intimate conversation. Today, we're going to have a quick topic. We're going to be talking about the importance of telling your lawyer the truth and what can happen if you don't. It's a very important topic, and before we dive in, I'll do a little check-in with you. How am I doing, and am I a warrior or a diplomat today? You know that's our thing here at Hastings Shadmary. As we say, we're both warriors and diplomats. For me, it's kind of a hard question to answer because I believe that warriors have to be diplomats. So for me, I'm always kind of a combination of both, but I actually am coming off of 2 days of rest. I had a lot of buildup over the past few months. I needed to step away to recalibrate myself. That's something that used to be very hard for me to do. And I feel like it's been a huge success to get myself to a place where I can go and take 2 days to recenter myself. And I did that. I believe it makes me a better advocate to schedule time like that for myself. It's very rare. Maybe once or twice a year I'm going to do something like that. And this is the first time in my life I was able to do it without making myself feel guilty the entire time. And I've worked for probably 2 years consistently to get my personal self to that space of not feeling like I have to go be doing more. Instead, treating rest like it's part of my job. So with that being said, I am coming to the table today as a warrior, total warrior, have my eye on the prize. We've got several legal teams here with big trials coming up, and it's my job to step in and help lead the troops and give guidance and expertise, probably try a couple of these cases with our lawyers, get in there in the courtroom. We also just came off of a really important event for the Forsyth County Bar Association. We had Law Day, which is something that I'm very passionate about, and I'm just feeling a lot of revved up energy around me. Loving being in the gym, doing bodybuilding. If you know me, that's what I am doing on the side. It's my side passion in addition to family law, and I'm in a bulk right now. So that's one of my updates. If you watch the podcast, you can see me change over time, and I love that I can share that journey with you guys a little bit. I know that's not why you're here, for me to teach you about that, but it's part of me. And so my job right now in the gym is to lift as heavy as I can, make sure I'm eating clean, but eating a lot. So I'm putting on some size because I'm going to be competing this year, and it's been really fun, but definitely a warrior mentality in the weight room, lifting weights heavier than a lot of the men, if I'm being honest, and I love it. So if you see me in the gym, come on over, and you're going to have just as strong of a performance in the gym with me as you are in the courtroom. So that's where we're at. That's where I'm at in my head. And now I want to talk to you as a potential client. Maybe you're one of my clients. Maybe you're someone who may need a lawyer of any kind one day, not just family law. What I'm about to teach you applies to really any professional that you're hiring, honestly, including lawyers and most importantly, lawyers. So I want you to picture something for me. Picture you are in the middle of a divorce. You're in the beginning stages of a divorce. You are going to a temporary hearing with your lawyer. You know you're going to have a final hearing one day, but you guys need a temporary hearing in the interim to figure out what are we going to do with our kids. And you have spent $30,000 from the date you hired your lawyer to the date of this temporary hearing. You guys have prepared for this temporary hearing to the nth degree. Perfection. Remember, with a lawyer like me, for example, we come correct. No stone is left unturned. I've taken all this information that my client has given me, and I have choreographed it into the perfect flow to communicate to our judge to get the outcome that we want. And you and I are going to court today, to just fight for your children, to get you temporary custody so that we can get through the rest of this case and get to a final conclusion. Your spouse, let's say you're the husband, your wife has been withholding the children. We can't get parenting time for you without this hearing. And everything is riding on this hearing. You've spent so much money. We have 100 exhibits. Everything is prepared. All right. We get to court. We walk in. Everything's perfect. You go up to the stand. You testify. I'm here as your lawyer thinking, wow, that went picture perfectly. There's no way that we're not going to get what we're asking for. We're going to get custody of these children today. Everything's gone according to plan. Well, then the other lawyer gets up in the courtroom, to cross-examine you. And they have their own evidence. We don't know what that's going to be until we're in court watching it play out. And other lawyer gets up to cross-examine you. And what do you know? They put up some evidence that I, as your lawyer, has never seen before, that you've never disclosed to me. And it happens to be evidence that kills our case. That if I would have known as your lawyer that that was going to come out from the other side, I could have worked around it. But right here, right now, in this moment, you're on the stand and you are testifying without my coaching. I didn't know how to coach you on this issue because I didn't know that evidence even existed. I have to let it play out in the courtroom. And let me tell you, as that's playing out in the courtroom, Mama Bear is not happy. Lawyer is not happy. Lawyer is sitting here with her arms crossed, staring at you. I can't get you out of this one. When you're on the stand, you got to perform. I can't coach you when you're on the stand. We finish the hearing. You do not get custody of your children. In fact, you get supervised visits only, which is the opposite of what we were expecting, all because you did not share some very, very necessary information with your lawyer. In fact, you deliberately left it out, thinking no one will ever find this information out. You've now wasted $30,000, you've had a bad outcome in court, and you've got a lawyer that's furious with you. Because a good lawyer, we care about building a relationship and trust with our client just as much as you should care about the same with your lawyer. And when you go to court with a great lawyer, you are going with their reputation in your pocket. A good lawyer is known to take good clients to court. I'm not going to take a client to court if it's not worthwhile, and judges know that. That is my reputation. I take that very seriously. So when I have a client who, in my mind, hasn't had the decency to be honest with me, I am going to be furious. And there are going to be ramifications because it has now impacted your credibility in court, the outcome in your case, and my credibility as a lawyer. And I tell you that because that has happened to me before. That has happened to me in court before, and I'll usually withdraw from the client's case when something like that happens, which is a very hard decision to make. But if a client's not going to be honest, I can't perform to my best for you. And there is not anything in the world that you could tell me that would freak me out, that should embarrass you. You have to get used, especially in family law, you have to get used to the fact that you have to tell your lawyer the good, the bad, the ugly. That's how we can get you to the most efficient conclusion. 100% of the time that my client has chosen not to tell me information and it's come out through the other side, whether that's in trial or in discovery, I can tell you without a shadow of a doubt, my client has wasted time and money, and we have decreased the type of result that we can get for our client, the caliber of a result that we can get for our client. So a little bit more to expand on this for you. I want you to remember that there's such a thing called attorney-client privilege, okay? And in layman's terms, what that means is that you and I are in a bubble. As your lawyer, you can tell me anything in the world and it stays between us. It's a secret bubble. Now, if you bring third parties into the conversation, so for example, if you and I are having a face-to-face meeting and we're talking about your case, if you bring your friend with you to sit in on that meeting, you're waiving attorney-client privilege. We kind of open that up to the world. So you want your communications with your lawyer to just be kept between you and your lawyer. Don't let any third parties overhear the stuff. That means if that third party got subpoenaed to court one day, they could be asked, what did you talk to the lawyer about? What was the advice? They could tap into that privileged environment if they were called to, and we can't avoid that. So you and your lawyer speak in this secret vacuum. And for me, that it comes with trust. And really, though, that trust has to be established from the time you have your initial consultation with your lawyer throughout the entirety of the case. And when is the most important time to tell the real truth and all of the messy details to your lawyer? It's day one. It's at the consultation, because that's the day where we are creating a game plan for you. And a good lawyer is going to see how this can play out from the very beginning. We're playing chess, not checkers, especially here at Hastings Shadmary. That's one of our core values. It's called seize the whole. We play chess, not checkers. And we want to take it a step further. We want to play 3D chess, not regular chess. We want to just blow it out of this world. The best way to allow your lawyer to do that, give them all the information in your head from the very, very, very beginning. And I always tell my clients, it's best if you organize your thoughts and your notes and the big, scary, messy things that you know you need to address, get it out on paper before you even meet with your lawyer the first time so that you're not scrambling the day of and dealing with the nerves and anxiety. We've got a roadmap that we can be working from. So that's number one. Carry that with you is attorney-client privilege. It might feel icky, embarrassing, mortifying to say certain things. You may be saying out loud for the first time things that you've kept inside, whatever it might be. Embarrassing things if you had an affair, if you've been spending money on a significant other, if you've been struggling with addiction. You name it. If it's, I really just don't like being around my spouse anymore. They gained a lot of weight and I feel like a terrible person for saying that, but like I'm not attracted to them. Whatever it is, get that judgy feeling out of your system. Your lawyer's not judging you. And if they are, there's a time and a place for them to give you that feedback in a way that's productive. And that's up to you as you guys gain trust and learn how each other communicate. So some stuff that can go wrong. How does it impact your case if you don't tell the lawyer the truth? I mean, I just gave you story time and it plays out in trial. Okay. That's number one is we could be in court and we're getting surprised with this information and judges know when that's happening and it is terrible. So that's number one. That's probably the worst of the worst is you go to trial and it comes out in real time that you've hidden information. Case closed, you've lost all credibility. But what also plays out is typically what we see is information starts to come out from the other side throughout the pendency of the case. So remember, discovery is a 6-month process. It's a 6-month window. It's the fact-gathering process. And in discovery, you can do things like send written requests called interrogatories and requests for production of documents. You can send requests for information. And you can also send requests for admission. Those are just written questions basically saying true or false, kind of, you did this, you said this. They can try to seek information from you. They can take depositions. And what happens is when we're not forthright from the beginning and sharing enough information with the other side, they are going to keep probing and extending this discovery window of 6 months. You don't have to take that full 6 months, but the more you don't share information, the longer your case is going to get dragged out because the other side's going to keep probing and say, you didn't produce this credit card. You didn't produce 2 months of credit card statements. We need to see this because we believe you are spending thousands of dollars at Louis Vuitton on your paramour, and we're entitled to that information. I'm telling you right now, the more you do not provide this information to your lawyer, and this happens a lot, the more you just straight up refuse, the longer your case is going to take and the more it's going to cost because very rarely are you allowed to just not share information like that. Financials, things in discovery that the other side requests, your lawyer is gauging what you do and do not have to produce. And when your lawyer says that you must produce certain things, you have to. And I'm telling you that because I have had clients who won't do it. And what happens in those situations is you're setting yourself up for huge risk for attorney's fees. The other side can file a motion to compel against you to get this information out of you. There's no way around it. Judge is going to make you do it. Now, there are some caveats, and remember this. Your lawyer has the right to object to certain requests if we feel that it's harassing to you, but the law is very particular on when that's appropriate. So what you have to do, what the big rule of thumb is here is give your lawyer everything in the world that they're asking for. The lawyer will decide what to share with the other side and when and how it's going to impact your case. If there's something totally damning to your case, are there ways to avoid sharing that information? Absolutely. And there's ways to do that legally. And it's really too much and too complicated for me to even explain how that is now. But with a lawyer that knows family law and knows the Civil Practice Act, that's the civil rules that govern how to deal with discovery and other things in civil cases. With a lawyer that knows that, like the back of their hand, you give them the evidence, even if it's dirty evidence and it's like, oh my God, this can't come out. It's a video, whatever it is. Give it to the lawyer and you'd be surprised at how crafty we can get and still obey the law. We're not ever going to take you. A good lawyer is not going to do something that's illegal. We cannot do that. But you'd be surprised what we can get you if we know what the weaknesses are. And then we can craft our game plan around those weaknesses and avoid sharing the information. We've done it a lot. And the more high profile the case is, the more money at stake, the more important that becomes. So the rule of thumb, give your lawyer all the dirty stuff from the very beginning, throw it at them. That will allow us to create a much more fluid approach and one that can sort of give and roll with the punches and still protect you, if that makes sense. And so knowing the truth really affects our ability to strategize as well because settlement is optimal in most cases. And what we always say here is great trial lawyers make even better settlement lawyers. We do. And you are going to fare much better, typically, in settlement. If your case has to go to trial, it's because the other side, if you have a good lawyer, is not being reasonable and you'd rather take chances in front of a judge or a jury. And knowing, like I was just saying, knowing what your weaknesses are in the case prior to even starting settlement negotiations is very important. And I have had cases with just terrible evidence and some big blunders that could have happened if we didn't settle quickly. So if I know that the evidence is going to be tricky down the road and that there's a big chance we're going to have to share some tricky evidence later once the other side requests it. Remember that. Other side's going to request evidence and you have to share it. If we know that those requests are going to come out, settlement early is going to help you. And before we have to share all the credit card statements, all the text messages, whatever it is between you and your lover or whatever happened, let's go ahead and try to settle. Well, we can do that better when we know what our weak points are. So keep that in mind, that it's not only going to impact your settlement strategy and your trial strategy. And I would say that the last component here is, and I think it's underutilized and underdiscussed amongst litigants, clients, and their attorneys. Trust has to be maintained between the lawyer and the client. I am someone who will fight for you to the death. If you have trusted me with your life, your children, your money, your well-being, your peace of mind, I am going to fight for you like I would want someone to fight for me. And personally, it really, really lets me down. And I'm very disappointed when I find out that a client hasn't been forthright with me because I've been all in, invested. I am your biggest cheerleader. I will give you tough advice. I will do it with love, though. I am coming from a place to get you into a new chapter, to keep you looking at what's coming in your future and getting you there. And by not giving me all the information I need, I feel like I'm being stifled as your advocate. And for me personally, there is nothing that pisses me off more than someone who is going to deliberately hold me back in life, in my cases, with my reputation, and also with my protection of you. So you're hindering yourself by not being totally forthright with your attorney. And if you are not comfortable enough with your attorney to share everything with them, that's a problem. That's not the right fit for you. You should be in an atmosphere where you can let it all out. Let it all hang out. Let it. That's what we're here to do. I've had people that have gotten embarrassed about telling me how much money they make. They think they don't make enough and they're embarrassed to say it out loud. Things like that. Get that out of your head right now. Lawyers, we don't see it like that's no different than when you go to a doctor. They are used to seeing every type of body, every type of grossness, whatever it is. It is their job. It's what they're trained to do. Same thing for us. It's a safe space, and that's all I've got for you. Carry that with you when you're going into your consultation with your lawyer. Be ready to address the things, have some bravery to do it, and truthfully, do not think that you're sneakier and craftier than your lawyer if you hide information. You're setting yourself up for extra fees and a worse outcome and a relationship with your lawyer that's not sustainable. So I hope you can carry that with you. Thank you for letting me give you my little pep talk. And please make sure you follow us on our social media, Facebook, Instagram at Hastings Shadmary. Follow us on Spotify, YouTube, Apple, iHeart. Watch the show, share it with your friends. Message us if you're interested on joining us to speak as a guest. We're always looking for new guests on the show. And stay tuned for some updates on what's to come for the show in the future. Thank you, and we'll see you next time.
The Hastings Shadmary Show is a production of Hastings Shadmary Family Law and 1066 Productions. It is produced and edited by Ned Hastings.